New York, connected to my alma mater, New York University. It illustrates that since 2001, 41 states introduced 180 restrictive laws. Those states are illustrated by the red on the map, parenthetically a curious choice of colors, but those states are illustrated by the red on the map. 41 states introduced 180 restrictive laws. And then you have 34 states introduce photo identification requirements. 17 states introduced proof of citizenship requirements. 16 states introduced bills to limit registration, and 9 states introduced bills to limit or reduce early voting periods. Unprecedented in the history of our democracy. I just went through the election of several presidents who were inaugurated post the 1965 Voting Rights Act, but for some reason the American people are smart enough to draw cause and effect. When this president was elected, we had an outbreak of concern related to alleged fraud. Now, thankfully, the Voting Rights Act and Section 5 was in place to do something about it. I just talked about the fact that there were 41 states that introduced some form of voter restrictions. On this map, we see that as of October in 2012, there were 25 laws and 2 executive actions that were passed in a total of 19 states. A large amount of this activity, as you can see on this map, Mr. Speaker, took place in the Deep South and in Texas, states that are largely covered by the Section 5 preclearance requirements. Let me just pause parenthetically and note what's also interesting is there were 2 states, Iowa and Florida, that in the past had executed through executive order reforms designed to allow those who, as a result of the criminal justice system, had had their ability to vote taken away from them, restored through a process that had been put in place. But in the aftermath of the election of President Obama, what we saw is that in Iowa and in Florida, those 2 states, through executive order, those positive steps forward to make it almost impossible for those who had brushes with the law to ever be able to re-engage in the ability to participate in American democracy. And so these were laws that were passed, although because of the Section 5 preclearance requirement, not all of these laws actually were able to take effect. And that's an important point as it relates to the continuing relevance of Section 5's preclearance requirement. Now, as of October in 2012, approximately 12 courts either halted or blunted, they pushed back some of those laws that states had attempted to enact. Perhaps the most relevant example of why Section 5 continues to be relevant, Mr. Speaker, is what took place in the Lone Star State, the great state of Texas, where the legislature passed what would have been the most restrictive voter identification law in the country. It would have prohibited potential voters from presenting student college identifications. They were deemed in this law as invalid. It would have prevented voters from presenting state government identification. IDs that were actually issued by the state of Texas would not have been valid under this law. I find it interesting, particularly in light of the current debate that we're having related to how we deal with gun violence in America, is that one of the forms of ID that actually would have been accepted was a license that allowed an individual to carry a concealed handgun permit. Now, this was too much for the Justice Department and those who, in good conscience, seek to defend our democracy to accept. And because Texas is a covered jurisdiction, it had to be presented for pre-clearance by the Department of Justice or a 3-judge panel, and it was rejected. And so this law, though passed, never took effect. The same thing happened in Alabama. The same thing happened in South Carolina. There's a law that was passed by the state of Florida that is under consideration, and so as a result, even though many objectively believe it was designed to suppress the vote, it did not take effect in advance of the 2012 election because it's under review by the Department of Justice and their pre-clearance requirement. Mr. Speaker, in America, certainly we have come a long way, but we still have a long, long way to go. Jim Crow may be dead, but he still got some nieces and nephews that are alive and well. And until every single descendant of Mr. Jim Crow are dead and buried, we at the Congressional Black Caucus believe that the Section 5 pre-clearance requirement of the Voting Rights Act remains as relevant today as it was when it was passed